Hello everyone, I am Bhuvneshwari Goswami and I welcome you all to today's session. Today's session is a dialogue on the topic of comparative analysis of rules and procedures of various arbitration institutions across the globe. The speaker for this session is Advocate Goel Damkani, who is an Israeli qualified attorney specializing in the field of international arbitration, in collaboration with Advocate Gideon Fisher, who is the founding partner of Gideon Fisher and Company. The session will be moderated by Mrs. Shivangi Sinha, who is the Assistant Professor and Faculty Coordinator of Bharati Vidyapeeth deemed to be University's College Pune's Madhyasthta ADR Cell. Over to you, ma'am.
If you're ready, then I'll just post up my first question with just a basic thing. So according to your views, what do you think what is the main difference between the ad hoc arbitration and the institutional arbitration, which we hear?
Right. Well, ad hoc arbitration and institutional arbitration are actually, I would say, the two primary ways of conducting arbitrations. And the main difference is that institutional arbitration is what it sounds like. It's arbitration that is basically administered and supervised by an institution, meaning that the parties would be expecting that there would be a more institutional involvement or more intervention within the process of the arbitration than if they simply decided to, take advantage of the greater degree of flexibility that ad hoc arbitration offers. At the end of the day, we need to remember that ad hoc arbitration and institutional arbitration, whatever method the parties choose, they'll still enjoy a great degree of autonomy and flexibility in determining the procedure to follow. For example, even in institutional arbitration, the parties are still free to decide the mechanism for appointing arbitrators. They can still appoint or at least nominate the arbitrators that are subject to the institution's appointment, for example. The parties can agree to procedural timetables, for example, in institutional arbitration. But ad hoc arbitration allows the parties an even greater degree of flexibility because there isn't the supervision and the involvement of an institution. The thing is, actually, if you look at the development of ad hoc arbitration, it's not really that far off from institutional arbitration, meaning that parties can still, for example, decide to get an institution involved in certain respects. For example, if you look at the rules of the Hong Kong International Arbitration Center, they actually provide administrative services to parties that want to engage in ad hoc arbitrations. Even if the arbitration isn't conducted under the HKIAC rules, the HKIAC can still act, for example, as an appointing authority for arbitrators. Okay. And even if the parties decide to apply the UNCITRAL arbitration rules, they can still, for example, turn to the Permanent Court of Arbitration, which could act as an appointing authority. And so you still have examples of institutional involvement even in ad hoc arbitrations. And so I would say that the degree of distinction isn't as great as one might think. But yeah, you still do have to parties still do have to take into account the fact that institutions, if they prescribe to rules of institutions, then they would necessarily be agreeing to administration by that institution. So for example, you can look at the HKIAC rules or the ICC rules or other rules that basically say if the parties prescribe to those rules, then they agree that the administration or the institution will supervise and administer those rules.
Okay. Sir, I think you also answered my second question, which I was about to pose. So my second question was basically what, in your views, are the advantages of the ad hoc arbitration over the institutional arbitration? But as you mentioned, then the prior one is much more flexible. But do you want to add on anything more to it, sir, that when it comes to the advantages, that which if the party wants to go for anything, so what they think, that what is their opinion about that, whether they should opt for ad hoc or they should go for institutional?
Of course. Actually, it's important to take a step back and examine the nature of different disputes. So for example, in certain types of disputes, ad hoc arbitration might be preferable to institutional arbitration. For example, in a survey conducted by Queen Mary Law School in conjunction with White and Case, they found that certain industries and sectors actually either preferred ad hoc arbitration, or ad hoc arbitration was most predominantly chosen in those sectors. For example, if you look at the maritime sector or other sectors, maybe ad hoc arbitration would be more preferable. If there's a dispute that would involve a great degree of complexity, then maybe it's better for the parties to submit that dispute to an institution, because they would be perhaps better able to handle the intricacies of that dispute. The thing is, a lot of institutions, one of the advantages of institutional arbitration is that some institutions have more tailored rules for certain industries. Like, for example, the HKIAC has rules that uniquely apply to securities arbitration or electronic transaction arbitrations. And in addition, the rules of arbitral institutions, they're very sophisticated, and they have developed over time to meet the needs of the business community internationally. So, for example, if we look at trends like the quite early adoption of emergency arbitration procedures that allow for more urgent interim relief even before the arbitral constitution, even before the arbitral tribunal has been constituted. If we look at expedited procedures, fast-track procedures, summary disposition procedures, even the HKIAC has come out with unique third-party funding provisions. And so all of these are examples of how institutions are sometimes better fit to develop their rules to meet the needs of the business community. And if you think about it from more of a legal perspective, the unique institutional rules, they're also interpreted by the institution. So, for example, if the parties have a great degree of legal certainty and predictability, not only that they know the rules are prescribing to, but also, for example, the ICC court, the LCAA court, the HKIAC, they actively interpret the rules that they apply. And so you have a set of rules that are very predictable and that have been interpreted and applied on a uniform, consistent basis throughout many arbitrations. And in addition, as I mentioned, the administrative and supervisory functions that institutional arbitration offers can lead to more efficiency and more streamlining of the procedures. And if you look at possibly the latest stage of an arbitration is not the final award, but rather enforcement of arbitral awards. And even though the New York Convention provides a very robust mechanism by which arbitral awards can be enforced, it has been shown that sophisticated and leading arbitral institutions that do render arbitral awards, they're more easily enforced, meaning that the courts of various nations and countries will greatly respect arbitral awards that have been issued by, for example, the ICC. And that's because, institutions like the ICC and the LCAA and the HKIAC and other institutions, they're very respectable, they're very reputable. And if you look at the ICC, for example, and there are other institutions where the award cannot be officially signed until the institution has actually scrutinized the award and approved it as to form. So an institution does offer a certain degree of kind of like a stamp of approval, if you will, on the arbitral award. Now,
so basically, sir, it's like it totally depends upon the parties, and then when they are opting, it is totally on the institutional and ad hoc that what kind of rules and regulations are being adhered further. So this brings to me for the next question, which I want to pose to you. So do you think that there is any kind of jurisdictional issues which has been involved in these when we come to the international arbitrations?
Right. Well, first of all, kind of to wrap up the previous question, one of the one of the biggest drawbacks to institutional arbitration are the costs that are involved, because when you're talking about the administration of an arbitration, for example, in an institution, there will be administrative fees, there will be a lot of other expenses apart from simply the fees to the arbitrators. So the costs are a bit of a drawback. So sometimes if the parties are especially sensitive to costs, they might opt for ad hoc. So going into your questions on jurisdiction, there are many different types of jurisdictional issues that could arise in international arbitration. And I'll only speak about a couple of those issues. So you have issues that arise at the very beginning of arbitrations, and then you also have jurisdictional issues that arise at the very end of arbitrations, even at the enforcement stage or the post-enforcement stage. If we look at the beginning of arbitral proceedings, a lot of times a party might actually breach the arbitration agreement by submitting a claim to a national court. And if such a claim is submitted to a national court, then the New York Convention actually offers, and the New York Convention is a very widely accepted convention. It's been ratified by the majority of countries, over 150, 160. And the role of the New York Convention is to actually enforce and ensure the enforceability of arbitration agreements and also arbitral awards. So, for example, if a party breaches an arbitration agreement, a binding arbitration agreement, by submitting it to courts, then the courts of that jurisdiction would be compelled to, in a sense, to stay to stay the court proceedings in favor of arbitration. Now, this is a jurisdictional issue that is fairly simple, but it's important to look at the seat of arbitration. So even if a seat has ratified the New York Convention, there can be local issues, for example, pertaining to arbitrability or public policy. And many countries have adopted, for example, the UNCITRAL model law that basically says if a party submits a claim to courts instead of arbitration, then the party that wants to stay proceedings in court is able to do that, and the courts would have to transfer the claim to arbitration, save for very few exceptions. For example, if there is not a valid arbitration agreement. So you have issues of form requirements. Is there a written requirement? What is the scope of that requirement? Is there an arbitrability issue? And so it's important to look at the local law of the seat of arbitration that the parties have chosen to see what their policies are in this regard. You can equally have jurisdictional issues after the award has already been rendered. For example, if you look at jurisdictions like France, France has adopted a very pro-arbitration policy. For example, they will enforce arbitral awards even if the arbitral award has been set aside at the seat of arbitration. Other jurisdictions have followed suit. So it's important to choose a seat of arbitration and to keep in mind where the arbitral award is likely to be enforced. So for example, if an arbitration is commenced, and let's say there's a jurisdictional issue that arises or a jurisdictional challenge, then the tribunal has to take into account not only the law of the seat, but also it has to take into account the enforceability issue. Will the tribunal be able to render an award that will be enforceable? And this is actually an obligation that's imposed on tribunals. For example, under the LCAA rules and various institutional rules, tribunals do have an obligation to ensure that an award they do render is enforceable.
Okay. So your answer brings to the next question, since you mentioned about the seat of arbitration. So my next question, which I'm going to pose to you, is related to the seat of arbitration. So according to you, why do you think that the parties mostly prefer London, Paris, Hong Kong as the most preferred of seat of arbitration for them?
Right. Actually, you can also throw in Singapore and Switzerland. They're also very popular seats. There are actually a couple of reasons. The first reason is a more straightforward and practical reason. For example, these cities you've mentioned and countries you've mentioned are commercial hubs. They're very important commercially and economically and financially. Also, they're very convenient geographically. It's easy to fly to Europe, to Hong Kong, to New York, to these places to conduct arbitrations. They're very convenient places to conduct these
Easily
arbitrations.
accessible for the parties to reach to the places.
Exactly, accessibility geographically, but also legally, there are important factors to consider. So, again, going back to this authoritative survey that was conducted in conjunction with White and Case and Queen Mary, they actually identified some of the factors that make it a particular seat attractive. So, for example, the general reputation and recognition of the seat, and some of the factors that make a seat very reputable and recognized as a viable seat are, for example, the neutrality and impartiality of the local legal system, the national arbitration law, and perhaps track record in enforcing agreements to arbitrate and arbitral awards. So, for example, if the parties can be certain that the seat of arbitration will respect arbitration agreements and will, for example, going back to the jurisdictional issues, will stay court proceedings that have been initiated in violation of a binding agreement to arbitrate. If the parties are aware and certain that the legal system they choose will in fact be impartial and neutral, because even though arbitration is a chosen mechanism, sometimes parties will go to courts for certain matters. For example, maybe they'll go to the courts for interim measures. Maybe there will be certain motions or requests that need to be submitted to the courts of the seat of arbitration, and the parties will want to be 100% certain that those courts will be neutral and impartial. And so these are very important considerations in choosing a seat. And perhaps this is why Paris, London, Singapore, and Hong Kong are very famous seats for arbitration.
Okay. Whenever we have any conflict of interest, so whether the parties are going for the litigation or whether they are going for the arbitration, there is one thing which is very common, and that is having the confidentiality clause. So my next question to you is related to the confidentiality regime, which is there in different arbitration institutions. So, what is your comment and what is your thought on the different constitutionality or the different confidentiality regime which we have and the different set of constitutions which they have for the same?
Right. Yeah, confidentiality is really an important factor. It's a key characteristic of arbitration. However, a lot of parties or counsel involved in arbitration have what I view as a mistaken presumption that international arbitrations will be 100% confidential. A lot of times, if the parties are very interested in confidentiality, they will need to put in clear terms confidentiality requirements within the framework of their arbitration agreement. However, there are many arbitration institutions that do guarantee a certain degree of confidentiality. So, for example, in my mind, the LCAA and the SIAC, the Singapore International Arbitration Center, offer perhaps the highest degrees of confidentiality, not only in terms of who the obligation is imposed on. So, for example, some institutions like the ICC will only explicitly impose confidentiality requirements on the court or with respect to the workings of the court. However, the LCAA and the SIAC or the HKIAC also, the confidentiality requirements apply to the parties representatives, the tribunal, any emergency arbitrator, experts, witnesses. And so the scope of confidentiality can vary from institution to institution. And so it's important in choosing an institution, if the parties are very interested in confidentiality, to choose an institution that has strong confidentiality provisions, but also to ensure that the arbitration agreement contains confidentiality provisions as well. Another aspect of confidentiality that is important is when it comes to the publication of arbitral awards. So, and this is actually an aspect that's pretty interesting because some institutions actually have diverged in their approach to the publication of arbitral awards. So, for example, the ICC used to take kind of a restrictive approach in terms of they'll publish awards only with party consent. However, from the 1st of January 2019 and on, the ICC actually changed their policy of publishing awards as a default. And so parties need to actually expressly opt out of the publication of awards. However, the SIAC has taken kind of the different approach, where before the SIAC actually published arbitral awards, but now one of the changes to these rules, which has been generally overlooked, is that they now require the consent of the parties and the tribunal before the SIAC may publish an award. Whereas previously, the rules permitted the SIAC to publish awards in redacted form without the parties or the tribunal's consent. And so it is important that the parties are aware also of the institutional rules and development with respect to the confidentiality of arbitral awards. And if I may bring up one last point, the LCAA has actually publish at least abstracts of decisions that relate to arbitrator challenges. And so not only in terms of the duty of confidentiality to keep the hearings private or the material that is exchanged private, but also the publication of awards.
Okay. So coming to my next question, I just want to give you a brief overview of the comparison of the summary disposition which we have, and which is related to the claims. So when it comes to a comparison of ICC summary disposition claim related to SIAC or your SSC. So what is a brief comparison or something which we need to focus or which we need to know about?
Right. Well, of course, summary disposition has traditionally been an authority that has been exercised by the courts. However, summary disposition has crept into international arbitration, where tribunals have actually ruled in these ways, and certain institutional rules have developed to include the possibility for a tribunal to exercise such authority. And it's where claims are submitted that manifestly lack merit. Also, it applies, so the scope of authority also applies in some cases to defenses that lack merit manifestly. Now, the difference between, you mentioned the ICC as opposed to the SIAC or the SCC, the Stockholm Chamber of Commerce. The ICC is a very interesting institution in which this summary disposition procedure has developed, because the ICC rules actually don't explicitly contain any provisions that deal with summary disposition, whereas the SIAC and the SCC, and also the HKIAC, do have explicit provisions that deal with these matters. The ICC rules, they contain Article 22, which is a general mandate to the arbitral tribunal to conduct the arbitral proceedings in an expeditious manner, an efficient manner. And so various tribunals have actually, in fact, de facto have ruled in summary disposition have used this clause and provision of Article 22 to base their authority to exercise such jurisdiction to rule in a summary way, and this authority has actually been upheld by various courts. So the ICC they have a note that's not included in the rules, whereas SIAC and SEC, they have it clearly laid out in express terms. Now, there are also slight differences with regards to the scope of the tribunal's authority in this regard. So, for example, the SCC rules are perhaps the broadest because they essentially authorize the tribunal to dispose of certain claims that are submitted with respect to a wide variety of issues, whether it's jurisdiction, admissibility, or merits. When it comes to the ICC, they pertain mainly to situations in which claims relating to merits or jurisdiction are manifestly without merit. And also with the SCC, there's kind of a catch-all provision where a request for summary procedure may concern issues or any issue of fact or law that's material to the outcome of the case, which is suitable for determination by way of summary procedure. And so it's important for parties when they prescribe to certain institutional rules to take into account the scope of the tribunal's authority in this regard. And of course, summary disposition is a trend that reinforces the notion that international arbitration is evolving to be more efficient, to be more expeditious. And I would also say that summary disposition kind of goes hand in hand with expedited procedure, just another mechanism whereby parties can obtain very efficient and swift results.
Okay. So putting my next question to you, when we go for any kind of proceedings, be it arbitration proceedings or any other proceedings, the two important factor which we come across is the time and cost. And as we all know that we have different kind of arbitration institutions, for example, London, from example, Hong Kong. So, sir, if I want to ask you that if you have to go for any suggestion and what will be your preferences, which institution which we can say is putting into account this particular twin system which we have of time and cost. So what is your comment on that? That how these institutions are actually looking into account with these certain factors and how are they ruling to the parties?
Right. Again, it depends a lot on the nature of the parties and their dispute. So, for example, if we're talking about a construction dispute that is very complex, involves multiple parties, and the documentation, the evidence, for example, is very broad, then it would be a stretch to conduct the entire arbitration and conclude it within a span of 6 months, for example. So a lot of times parties do want swiftness and a very quick award, but other times if the arbitration is very complex, then parties might prefer a comprehensive award that is very solid in terms of substance, and they would be willing to sacrifice a little bit of time for that. So it really depends on the nature of the dispute. Now, there are two competing views in this area. So, for example, the ICC does clearly state that a final award needs to be rendered within 6 months. Most institutional rules actually do not lay out a specific time limit like the ICC does. Some parties might view this as a disadvantage because they want the certainty and the predictability that within 6 months an arbitral award will actually be rendered. However, parties do enjoy flexibility. So, and in any case, the ICC court or the tribunal do have the authority to extend time limits. In my mind, the time limit is not really an issue, because in any case, if you look at institutional rules, most all institutional rules do impose an obligation of the tribunal to act efficiently and expeditiously. And actually, if you look at the institution, the VIAC, the Vienna International Arbitration Center, they've actually come up with a very innovative mechanism whereby the VIAC Secretary General actually has the authority to increase and decrease arbitrators' fees by up to 40% in light of the efficient or inefficient conduct of the proceedings. And so you see that a lot of institutions, they don't need an explicit time limit for rendering an award, but rather the fact that tribunals need to operate, and they have an incentive to operate in an effective and expeditious manner. It generally leads to very quick awards. And also, arbitrators are very aware of the fact that if they do delay for too long, then it could lead to possible challenges when it comes to enforcement of arbitral awards. And so they're always aware that you could kind of say perhaps this is due process paranoia. They are aware of due process issues. Now you also have the issue of if they do render an award too quickly, then they still need to make sure that parties have the opportunity to present their case fully. But generally, arbitrators and these institutions will be quite efficient in the way they handle these cases, and in terms of rendering an award in a timely manner.
Okay, thank you so much, sir. So my next question to you is that when we speak about joinder mechanism, so according to you, once again, your view on the same, which arbitration institution which you think could be preferred when it comes to joinder mechanism?
Right. And again, this all comes back to the nature of transactions, the nature of the parties involved in the dispute. So for example, and also the values that the parties deem important. So for example, if the parties want 100% predictability and certainty that only the signatories of the arbitration agreement will be bound to arbitrate the dispute, they might opt for the LCA rules, which are actually pretty strict in terms of not being so flexible in allowing for third-party joinders. However, if we're talking about complex transactions that involve multiple parties or multiple contracts that relate to a series of transactions, then parties might actually have an interest in ensuring that parties that might not necessarily have signed the arbitration agreement could still be brought in to arbitrate. And so, for example, the ICC rules do contemplate situations where even if a party has not explicitly signed the arbitration agreement, they can still be brought in if there's a sufficient connection to the dispute or to the contract involved. So one of the doctrines that has emerged is the group of companies doctrine, where a party might be able to join, for example, a parent company of a party that has explicitly signed an arbitration agreement. If that parent company, for example, has endorsed the agreement, has been involved throughout the process, for example, from the negotiation stage until performance of the contract, and where bringing in that parent company might lead to a just result. For example, if the party that signed the arbitration agreement really does not have the assets that the party that the plaintiff would need, or if an arbitral award were to be rendered against the party that signed the arbitration agreement, then they wouldn't have the assets to comply with the arbitral award. Maybe the parent company that does have those assets can be brought in under certain circumstances. So it's important for parties to be aware, first of all, for parties to make sure that all of the relevant parties have signed the arbitration agreement or the document containing the arbitration agreement, and that there's the mechanism is in place to make sure that an award will be enforceable. For example, if an award, if there are jurisdictional issues, then that could lead to enforceability issues with the arbitral award. So parties are very encouraged to take these issues into account in the negotiation phase in drafting their transaction. But they are still also encouraged to take into account the various approaches between institutions. So, these differences between, on one hand, like for example, in the ICC, where third parties can be joined. Now, there are some institutions that actually allow for third parties to participate in arbitration themselves instead of, for example, one of the parties that has signed the arbitration agreement being able to bring in another party for a party that is not a signatory to actually say, I have been involved in a significant way in this transaction and the dispute, and so I want to take part in this arbitration. That's another consideration, and different arbitral rules deal with these issues differently. Also, you have institutional rules that differ when it comes to the ability to consolidate arbitrations, to join multiple contracts. And so all these matters should be examined by a party when choosing an institution.
Next question is that arbitral institutions are involved in the administrating and managing of disputes, which we all are aware about. So this brings to my next question, that is, what is the level of institutional involvement which is allowed when it comes to the dispute between the parties?
Right. So, like I said, actually, I mentioned in the first question that you posed to me, is that by prescribing to certain institutional rules, parties do agree to certain levels of institutional involvement. So, for example, Article 1.2 of the HKIAC rules states that by agreeing to arbitration in accordance with the rules, the parties accept that the arbitration shall be administered by HKIAC. The ICC has a similar provision. And so by prescribing to international arbitration institutions, parties do expect a certain level of institutional involvement. Now, sometimes the involvement of institutions in procedural matters is something that the parties cannot necessarily control. So, for example, if a party wishes to challenge an arbitrator, then the administering body of that institution, whether it's the ICC Secretariat or Court or the HKIAC, they will be the final determiners of that issue. However, there are other procedural issues that the institution can step in and get involved in if the parties have not agreed otherwise. So, for example, if we're talking about the nomination and selection of arbitrators, for example, the ICC rules states that the parties are free to agree on the number of arbitrators, and they're free to agree as to a sole arbitrator or 3 arbitrators. But in the absence of party agreement, then the ICC will generally opt for a sole arbitrator unless there's a great degree of complexity to the dispute. Maybe the dispute involves a very significant amount of money that would justify a 3-member panel. And so the institution would basically step in the absence of party agreement. So it's very important for parties to be aware of their ability to, in a sense, choose some of the procedure of the arbitration and how it will be conducted. And also to be aware of the fact that if they do not dictate certain procedural terms, then the institution will have the power to intervene and be involved in determining how to proceed in these matters. One of the important areas of institutional involvement, for example, that the parties need to be aware of is, for example, with ICC arbitration, sometimes there will be certain provisions that apply automatically. So, for example, in ICC arbitration, if we have expedited procedures or fast track procedures, where if the claim is below a certain amount of money, then the expedited procedures will apply automatically. unless the parties have expressly opted out, and that the institution will appoint a sole arbitrator even if the parties have agreed in the arbitration agreement that the arbitration will be heard by 3 arbitrators. And there have actually been cases where arbitral awards issued by the ICC have been challenged on the basis that the expedited procedure was heard by 1 arbitrator in contradiction to the parties' agreement to have the arbitration heard by 3 arbitrators, but the final ruling was that by prescribing to ICC arbitration, the parties necessarily subjected to the ICC's authority in this area. And the ICC rules actually state that notwithstanding the parties' agreement as to the number of arbitrators, when there are expedited procedures, the parties will have to arbitrate with a sole arbitrator. However, there are other institutions, for example, it's evading me at the moment, but other institutions, at least one allows for, I think the HKIAC, they allow for parties to nonetheless have 3 arbitrators in expedited procedures. So the parties do need to be aware of when they prescribe to a certain institution, what are the areas that they have influence over, and what are the areas that they don't really have a say in. And if the parties are aware of these matters, then this will lead to less confusion, less challenges, less objections. And so it is important that the parties do examine the rules of the institution and the level of involvement that that institution would take on in an arbitration.
Okay. This brings to the last question of this session, sir. Many a times parties seeks for emergency arbitration procedures according to their needs and demands. So what are the rules and provisions which are being followed in the different arbitration institutions when we speak about the emergency procedure?
Right. So emergency arbitration is actually another way that, going back to even a comparison between institutional and ad hoc arbitration, it's another way that institutional arbitration has, in a sense, set itself apart from ad hoc arbitration, because this is only one more example of how institutional rules are very sophisticated and they evolve to develop with the times and to meet the needs of the international business community. And so all institutions, they do provide for interim relief that the tribunal can grant. But what about interim relief that needs to be granted on a very urgent basis before the tribunal is even is constituted? And this is what emergency arbitration deals with: is before the constitution of the tribunal, parties can apply in exceptionally urgent cases for emergency arbitration. And actually, most all of the leading institutions like the ICC, the LCAA, and the HKIAC and others do provide for emergency arbitration, and the rules are very, very similar, both in terms of the authority of the emergency arbitrator and also in terms of the timeline by which the emergency arbitrator is to be appointed, and also the timeline by which the emergency arbitrator must render its award. However, there are actually, in my opinion, one of the main differences has to do with the ability of the emergency arbitrator to act in the subsequent main proceeding. Most institutions actually explicitly prevent an emergency arbitrator from taking on any role once the arbitral tribunal is constituted. However, if we look at rules like the HKIAC, then generally this will be the case, but the parties are free to agree that the emergency arbitrator can actually be involved after the emergency arbitration. For example, perhaps the parties do want the emergency arbitrator to be one of the members of the arbitral tribunal. But largely, the emergency arbitrator provisions are very similar across arbitral institutions. One last issue that needs to be taken into account is also the policy at the seat of arbitration. Okay. So, for example, at least in England, this has had the unexpected consequence, meaning the development of emergency arbitration as part of institutional arbitration has had a bit of an unexpected result by preventing a party from applying to the English court under the English Arbitration Act. And this is because under the English Arbitration Act, if the parties have agreed to institutional arbitration, then they are required to exhaust those remedies before applying to English courts. So in one case, for example, in the case of Gerald Meadows' SA versus Timmis and Orrs, the court held that a party was not entitled to apply to the court for a freezing order under Article 44.3, where that party could make an application for the appointment of an emergency arbitrator pursuant to the LCAA rules. And so the parties do need to be aware that while these emergency provisions have allowed institutions to be more flexible in terms of the degree to which they can issue interim relief and answer the needs of the parties do need to realize that this could affect their ability to obtain relief at the seat of arbitration through the courts. And another matter and one final matter that the parties need to be aware of is whether the emergency arbitrator provisions are an opt-in or an opt-out provision. So, for example, according to the ICC rules, the emergency arbitral provisions will apply automatically if the parties have entered into their arbitration agreement on or after January 1st of 2012, where those rules have gone into effect, unless they have explicitly opted out. And so it is important for the parties to be aware by signing up to or prescribing to certain institutional rules, whether those emergency arbitral provisions will apply automatically or if they need to opt out or opt in.
Okay. Thank you so much, sir. I think it was one of the most insightful session on the rules and procedures of various arbitration institutions which we had across the globe. So I'll just quickly summarize. I just need to mention few people around. So once again, sir, I, Shivangi Sinha, Assistant Professor of New Law College, Bharati Vidyapeeth, thank you a lot for just coming and making our initiative a grand success. I also want to thank you on behalf of our Principal in Charge, Dr. Bhagyashree Deshpande, ma'am, who is not there at present in this particular session, but is definitely going to thank you a much. And my whole team of ADR, especially Bhuvnesh, who is the student representative of this whole particular initiative. Thank you, Bhuvnesh, and thank you, sir. Thanks a lot.
Thank you so much.
Thank you so much for allowing me the opportunity to contribute.
Sure, sir. Definitely.